A very good morning to all my dear students. Today we are going to discuss about the concept of general provisions as to appeal. As you all are aware that there are two types of provisions given for filing or preparing or drafting an appeal. These are general provisions and specific provisions. But before starting with the same, I just want to apprise you the need for filing an appeal, as this is necessary for the better understanding of this topic. My dear students, the expression appeal has not been defined in the code, and the need for filing an appeal is that any person who feels aggrieved by any decree or order passed by a court may prefer an appeal in a superior court if an appeal is provided against that decree or order, or may make an application for review or revision. In certain cases, a subordinate court may make a reference to the High Court as well. So these are the remedies by which an aggrieved party may approach the higher courts against the order passed by the trial court in a civil suit. Further, an appeal, as the word appeal has not been defined under the Code of Civil Procedure. My dear students, as you all are aware that Section 2 of the CPC defines various words and expressions such as judgment, decree, order, foreign court, foreign judgment, and so on and so forth. But the legislature did not provide any definition relating to appeals. As such, we have to take the assistance of the law dictionary, wherein it is stated that an appeal is a judicial examination of the decision by a higher court of the decision of an inferior court. Further, as far as the case law on this point is concerned, the relevant case law is that of Nagendra Nath Day versus Suresh Chandra Day, AR 1932, Privy Council 165. Now, as far as the provisions relating to appeals are concerned, the same are divided into two parts, my dear students, and these are specific provisions and general provisions. Specific provisions relating to appeals have been provided under Section 96 to 112 and Order 41 to 45. Furthermore, first appeal provisions are given under Section 96 to 99A and 101. Second appeal provisions 103, 100 to 103 and 107 and 108 and Order 42. Further, appeals from orders are given under from Section 104 to 108 and Order 43. Appeals by indigent persons have been provided under Order 44 CPC, and appeal to Supreme Court is provided under Section 109, 112 and Order 45 of the Code of Civil Procedure. Now, we will have to discuss over here is that the right to appeal and its nature and scope. As you all are aware that an appeal is not a natural or an inherent right, it it is a creature of statute. It may be claimed as a matter of right. Further, it may be claimed at the discretion of the court as well. And the example for this is that of filing of an SLP under Article 136 of the Constitution of India, 1950. Further, right to appeal is a substantive right and not merely a procedural right. It is also a vested right and it accrues to the litigant as and from the date the litigation commences. Further, vested right can be taken away only by subsequent enactment if it's so expressly or impliedly provided by any statute. And this was so held in the case of Anant Mills Company Limited versus State of Gujarat, year 1975, Supreme Court 1234. Now, the form of an appeal of what is provided under Rule 124 of Order 41, and the relevant provisions are Section 96 to 99A, as it is a substantive right, and Order 41 CPC provides the procedural rights. My dear student, as you all are aware that for filing an appeal or for filing a valid presentation of an appeal, following requirements needs to be satisfied, and these are: memorandum setting forth the grounds. Second, it must be signed by the appellant or by his pleader, and it must be presented to the court, and it must be accompanied with the certified copy of the judgment. Now we will have to discuss about the general provisions. General provisions have been provided under Section 107 and 108A CPC, meaning thereby it will be applicable irrespective. It would be applicable to all the types of appeal, be it an general appeal or appeal from an original decree or appeal from appellate decree or appeal from orders or appeal from an indigent person or appeal from Supreme Court. So these sections, Section 107 and 108, are generally applicable to all, and these are, as far as Section 107 is concerned, it provides the power of the appellate court, and this section has to be read with Rule 23, Rule 23 to 29 and 33 of Order 41 CPC, which would be applicable to all. And these powers are: power to decide a case finally. This is so provided under Section 107, Rule 24. Second, power to remand, Section 107, Clause 1B and Rule 23 and 23A. Power to frame issues and refers them for trial, Section 107, Clause 1, Clause C, Rule 25 and 26. Power to take additional evidence and power to modify decree, Rule 33. As far as the power to remand is concerned, the remand means to send back, and its nature is that where the trial court decided the suit on a preliminary point without recording reasons on other issues, and the appellate court reverses the decree so far, it may send back the case to the trial court to decide other issues and determine the suit. This is called remand. Rule 23A, as inserted by Amendment Act 1976, enables the appellant court to remand a case where the lower court has decided it on merits, but the appellate court considers such remand in the interest of justice. As far as the scope of remand is concerned, by passing an order of remand, an appellate court directs the lower court to reopen and retry the case, meaning thereby, my dear students, that by remanding a particular civil suit by the higher court to the trial court, it directs the higher court directs the lower court to reopen and retry the case either from the stage from which it was pending or decide it afresh. As far as the conditions for remand is concerned, these are given either under Rule 23 or Rule 23A. And these conditions are: number one, that the suit must have been disposed of by the trial court on a preliminary point. Second, the decree under appeal must have been reversed. And the other is other grounds. Rule 23A of Order 41, as inserted by the Amendment Act, empowers the appellate court to remand a case even when the lower court has disposed of the case otherwise than on a preliminary point, and the remand is considered necessary by the appellate court in the interest of justice. So this is the another ground. So my dear students, these are the three grounds on the basis of which an appellate court may remand a particular case from higher court to the lower court. What would be the effect of an order of remand? An order of remand reverses the decision of the lower court and reopens the case for retrial by the lower court, except in regard to the matters decided by the appellate court. So my dear students, from this we may infer that either the court may retry the whole case or to decide it afresh and except in regard to the matters decided by the appellate court. Now, what is the duty of the trial court when a particular matter has been remanded back by the higher court to that court? Once an order of remand is made by a superior court, an inferior court has to decide the matter as per the directions of the superior court. So my dear students, from this we may infer that they have to follow the guidelines given by the appellate court in deciding the civil suit which has been remanded to it by the superior court. Next. What are the duties of the appellate court? So these are the duties. Following are the duties of the appellate court. These are duty to decide appeal finally, meaning thereby all the cases or all the appeals which are going to be heard by the appellate court, they must be decided finally by the higher court itself. Second, duty not to interfere with decree for technical errors. And third one is duty to record reasons. It is the duty of the appellate court to record the reasons while deciding an appeal. As you all are aware that there is a principles of natural justice given under the admin law, and one of the principles given therein is that of reasoned order, meaning thereby all the decisions must be given by an authority. It must be a sound decision and also a reasoned order. And in case the reasoned order is not passed by an authority, then the same may be set aside by the higher courts. So this obligation is not only given or conferred upon the quasi-judicial bodies or the lower courts, but also upon the higher courts as well. Next. Second, the last provision with regard to the general provisions as to appeal is concerned is Section 108 CPC. It provides that the provisions of this part relating to appeals from original decree shall, so far as may be, apply to appeals from the appellate decree as well as from orders made under this code or under any special or local law in which a different procedure is not provided. So this is Section 108 of the Code of Civil Procedure. Now, my dear student, there is one specific question which I have to answer before parting with today's lecture is that what would be the effect in case there is a conflict between the specific provisions and the general provisions. To this, I would like to submit that the specific provisions would be applicable or would be applicable in case the same are in conflict or are inconsistent with the or are inconsistent with the general provisions of the code, that is the civil procedure code. And this is also having resemblance with the doctrine of repugnancy as provided under section 254 or article 254 of the Constitution of India, meaning thereby while applying the doctrine of repugnancy, the specific law would prevail over the general law. So this is all about today's lecture, my dear students. But before parting with today's lecture, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on reference by the lower court to the high court. My dear students, the law relating to the reference has been provided under section 113 of the Code of Civil Procedure and order 46 of the Code of Civil Procedure. As such, I hereby request you to kindly go through the same well in advance and which would be helpful to you in understanding my next lecture. My dear students, in case with regard to today's lecture, if there is any query in your mind, then you may write it to me at my email ID, that is rahulrora.gn@jagannath.org. Thank you very much.
ऐसी तुम्हारी आइडियोलॉजी है कि इंडिया में पढ़ के लोग कहां से
Thank you very much. We'll meet you soon in my next lecture.